ladies and gentlemen, we move on with the next part of the program, and another launch of sorts. We present two volumes at this juncture. One, a special supplement for Lawasia, and the other, a commemorative volume of the Bar Association Law Journal. I'd like to invite Mr. Yasantha Kodagoda, President's Counsel and Judicial Solicitor General, the editor of the special supplement, along with the deputy editors, Ms. Savini Idamalgoda, Attorney at Law, and Ms. Diniti Lianage, Attorney at Law, to present the copies of the special supplement to His Excellency and the other dignitaries present here.
We'd also like to invite the co-editors of the Bar Association Law Journal to present copies to His Excellency and our other dignitaries. I'd like to invite Mr. Eraj De Silva and Mr. Saravanan Neelakandan. Ladies and gentlemen, the Bar Association Law Journal is an annual publication of the Bar Association, and we also have this special supplement which has been published especially to commemorate this Golden Jubilee Conference of Lawasia.
We now present the Bar Association's special commemorative volume of the Law Journal to His Excellency. The co-editors there, Mr. Eraj De Silva and Mr. Saravanan Neelakandan. The delegates will receive their complimentary copies at the technical sessions, and so some reading material for you to look forward to.
Thank you very much. Ladies and gentlemen, it's now time to invite on stage the President of the Bar Association of Sri Lanka, Mr. Jeffrey Alagaratnam, President's Counsel.
Your Excellency, the President of the Democratic Socialist Republic of Sri Lanka, Honorable Maithripala Sirisena, the Honorable Prime Minister, Mr. Ranil Wickremesinghe, His Lordship the Chief Justice K. Sribavan, the Honorable Attorney General, Your Lordships and Ladyships of the Supreme Court, the Honorable Solicitor General, Learned President's Council, the Honorable Minister of Justice, and other Honorable Ministers, Your Lordship, Justice Vijit Malalgoda, President of the Court of Appeal, and other judges of the Court of Appeal, the High Courts and other courts, our visiting Chief Justices and judges of other jurisdictions, the President of Lawasia, Mr. Prasant Kumar, and his Executive Committee, and the past President, Mr. Suzuki, and the President-elect, Mr. Chris Leong, the members of the Executive Committee of the Bar Association of Sri Lanka, Your Excellencies, distinguished invitees, and colleagues. On behalf of the Bar Association, it is my privilege and pleasant task to speak on this significant occasion. To Lawasia, I say welcome back to our beautiful land. It has been 23 long years since Lawasia left our shores. Ours is a land that boasts of a great history, home to all the major religions of the world, and a land with many cultures and languages of which we are rightly proud. We are a nation of unity and richness in diversity, a nation of accommodation, and a nation that is bound, being the home of all the major religions, to observe true tolerance and perhaps more than tolerance of acceptance, and the acceptance ungrudgingly of fundamental realities, an acceptance that we as a nation have to be and should be well-founded on the fundamental democratic principle that all are equal. Ours is a nation that has been momentously influenced by centuries of Portuguese, Dutch, and British governance. Our laws in particular demonstrate common and civil law traditions apart from other systems of law. Ours is the third oldest Supreme Court in the world, having begun in 1801. We also have a long history of a rich jurisprudence and system of justice based on ancient traditions influenced by many religions, of which we are home to. We are here to exchange and share our respective experiences on different areas of the law, to enrich each other and also to chart our way forward. It is useful and necessary for us to periodically focus on and share our thoughts, to see how we are doing, as it were, and as to how we should be doing. This conference gives us all the opportunity to do so in the context of our respective countries. In charting our course, it is not only the experiences of the Asia-Pacific region, the base of Law Asia, that we need to look to, but we need to look beyond to other systems and jurisdictions in our constant learning process. In a wired world where we see the territorial boundaries of nations shrinking, we have to constantly innovate and move beyond narrow considerations or thinking to embrace new developments, concepts, and challenges to truly see the global perspective. We have eminent persons from the Asia-Pacific region and beyond too with us for this conference. We are honored by your presence. Whilst no doubt the coming days will see dynamic encounters in the law, it is our hope and wish that we will conclude our deliberations with something specific and concrete on the table to pursue and establish in our own spheres of influence. It is significant that we meet here in Sri Lanka today, the Golden Jubilee of Law Asia. It has also been an eventful period for us in Sri Lanka. We have seen 2 elections, a presidential and a parliamentary election in the past year. We have put behind an era best forgotten. We are privileged to have in our midst the 2 persons who were part of that great movement for change brought about in the last year. His Excellency the President, the Honorable Maithripala Sirisena, and the Honorable Prime Minister, Mr. Ranil Wickremesinghe. We have had a change of government or governance, and we in Sri Lanka presumably voted for a change and a change for the better. We are still hopeful. We do not fool ourselves with the thought that we have a perfect government or that everything is as we desire. We know that our national government, as we refer to it, comprises a broad spectrum of individuals with diverse views and interests, and not necessarily that all such persons have interests that are aligned or aligned with a united democratic country above self. We are conscious of the challenges faced by these 2 leaders who are here today, both from within and without. Whatever our laws may be and whatever developments and changes we desire, the fundamentals of democracy are a prerequisite to give meaning and relevance, if not life, to the law. Our government has pledged good governance, which after all is a universally accepted and adopted truth. Without this, all laws will remain only on paper. Across our region, we have had our profession playing significant roles in good governance, democracy, and the rule of law. We may refer to our brothers in Pakistan, India, and Malaysia in particular. We are no doubt deeply saddened and grieved by the recent assassination of the leader of the Quetta Bar in Balochistan, Pakistan, which reportedly occurred while on his way to court. The assassination or bombing of lawyers and civilians thereafter is ominous. We express our shock and condemnation and will pursue this matter with the relevant authorities. This incident brings home our conviction as members of Law Asia that enduring peace, however elusive, is something that we all have to cherish and preserve at great cost. We all long for a healthy and lasting peace in our lands. We have to embrace the basics of equality and fairness, especially in our systems of law and governance, if true peace is to prevail. Without these fundamentals, everything else will fade into insignificance. Truth-seeking and meaningful reconciliation for all the sins of all of us in the past is essential if true peace is to prevail. His Excellency the President and the Honorable Prime Minister have repeatedly assured us by their words and conduct that theirs is a representative role held in trust for the people. Whilst we appreciate the ups and downs involved in governance, we of the profession are mindful of the need for constant engaging and healthy cooperation towards achieving what's good and enduring. May we assure you that we will continue to do so no matter what challenges come our way. As a professional organization, together with the help of Law Asia, we believe that we have to play a professional and objective role bereft of political considerations to ensure good governance. Since, quite apart from those in governance, we too hold a position of trust for the people of our country, to whom alone sovereignty does and should belong. Peace and good governance are needed if laws are to be given vibrancy and true meaning and purpose. It is our wish that the deliberations of the next few days will see us stronger together, stronger in the conviction that the law has to be accessible to all, stronger in the belief that the law cannot be discriminatory but fair to all, that the law has to be relevant and people-friendly and not an oppressor, whether in its application or in the costs required in seeking redress or by delays in obtaining relief. It is only then we could say that the law is truly for all and that the rule of law prevails. While wishing this conference all success in the days ahead, we are grateful for your presence and for your support. Thank you.
Ladies and gentlemen, it is our privilege to invite the keynote speaker at this inauguration ceremony, the Prime Minister of the Republic, the Honorable Ranil Wickremesinghe. A bit of trivia. A little bit of trivia as he makes his way up. We understand that he is the only person to have delivered the keynote speaker at an inauguration of Lawasia in its 50-year history, and spoke previously in 1993, then too in his capacity as Prime Minister.
Sir, please do us the honor of addressing this gathering.
His Excellency Maithripala Sirisena, President of Sri Lanka, Honorable the Chief Justices, the President of Lawasia, Honorable the Ministers, members of the Judiciary, Attorneys General, the President of the Bar Association of Sri Lanka, members of the legal profession, distinguished guests and friends. I must thank you for having invited me, and I consider it a privilege of being able to attend the third Lawasia conference held in Sri Lanka. But I attended all three not in my capacity as representing the Bar Association, but as a member of the government, first as a minister and twice as the Prime Minister. I must thank Lawasia for all the support you have given us. Otherwise, we would not have been able to hold this Lawasia conference in Sri Lanka. You wouldn't have come here. It's a recognition of the role that the legal profession in Sri Lanka also played in ensuring the consolidation of democracy and upholding the rule of law. This is a tradition which is inbuilt in. It is something is inherent in us because, as Jeff mentioned, our legal traditions are very, very old. And when you talk of the courts and you talk of the profession, you've forgotten two other groups. Firstly, the close relationship that has existed between the bar and the legislature and its members. When the Supreme Court was re-established, was upgraded by the Charter of Justice of 1835, provision was also made for lawyers to be admitted to the bar by the Supreme Court as proctors to the district courts and as advocates to the Supreme Court. And the first of those who entered and enrolled themselves and was admitted as lawyers were also among some of the first educated Sri Lankan members of the Legislative Council. The Legislative Council was also established in 1835. And the role of the legislature, not being an instrument of the governor, but reflecting its own position, was first established by Charles Ambrose Lawrence, a lawyer who sat in the Legislative Council of Sri Lanka. Rather than listen to the colonial dictates, he at that time quoted the British Parliament and people like Hampden and Wilkes, who said that the Parliament was supreme. The Parliament could not be supreme in a colonial constitution, but nevertheless he carved out the separate role for the legislature, which has been followed subsequently by many members of Parliament. The other group that is even more important, the people of Sri Lanka. They learn to appreciate the rule of law and the democratic system. So at a time when the rule of law was being undermined and democracy was on partial holiday, on a life support system, and when the judiciary was under threat, both from within and without, I must record here the role that the Bar Association and the civil society played with us in re-establishing the democratic and the legal order. It is something inherent in the South Asian system. Our commitment to a rules-based legal system goes back to the edicts of the great Emperor Asoka contained in his pillars. Our ability to absorb the systems, the legal system, and the principles of the British legal system, and the principles involved, that we, together with United Kingdom and the United States, became the other leading practitioner of the Anglo-Saxon legal system. But we had our own adaptations to it, and lawyers always played a leading role. In fact, the carving of the birth of the modern Indian states were done by 3 lawyers, Gandhi, Jinnah and Nehru. They decided what was going to be the future of that subcontinent. But it also meant the lawyers were willing to fight, to stand up and fight. Like in Sri Lanka, in India, in Bangladesh, and in Pakistan. And I joined Jeff in expressing my condolences to the Bar Council of Pakistan. You have always stood up for the rule of law, and that's a greater fight than what we have had. And now we have got to stand up to terrorism. So I think it's only fair that Lawasia expresses its solidarity with the Pakistan Bar. The result of the struggle that the political parties then in opposition, the legal profession, civil society, groups of the media journalists, and even the former President Kumanatunga finally brought about a coalition of political forces, not seen in Sri Lanka since independence. When we all got together and decided while we had to keep our separate identity, we had to cooperate and coordinate activity to ensure, as I mentioned earlier, democracy and the rule of law was preserved. And we were given that opportunity with the holding of presidential elections in advance, where we found, and I must admit, that His Excellency, as the General Secretary of the Sri Lanka Freedom Party, was willing to sacrifice it all to come along with us to contest the election. And that was the beginning. After he was sworn in, after we formed a government, we faced our first crisis immediately. The lawyers wanted to know who was the Chief Justice of Sri Lanka. And the courts were not functioning. Because when a motion of impeachment was presented to Parliament, in keeping with the Constitution, a select committee had to be appointed. The select committee then gave its report, and the correct legal procedure was then to move a resolution accepting the findings of the committee and moving the resolution to remove the Chief Justice. In their wisdom, the government's legal officers and others moved the same resolution which was moved earlier to appoint a select committee of Parliament for the second time after the report was presented. So I had the duty as leader of the opposition to raise and say that there was no resolution before the House to remove the Chief Justice. Nevertheless, when this odd resolution was passed by Parliament, the President, in exercising his powers, claimed to have removed the Chief Justice. There's very little the Chief Justice could do when the Chief Justice is thrown out of the House. But when the election was over and the electorate had given a resounding verdict in regard to the so-called impeachment, the bar wanted immediate ruling which could be given by the executive, and the executive ruled that there had been no proper removal of the Chief Justice. And when that Chief Justice took over, she created a new precedent by establishing the principle and resigning the office the next day. So within our system, we found a way out. Some thought that we would have to move another resolution or bring a law or amend the Constitution, not so. Parliament also is another court, and we have our own rules and procedures we follow. And we decided that we should, in this instance, ask the President just to give a ruling as to whether the Chief Justice has been removed by the President or not. Once that declaration was given, the Chief Justice came back to hold office. But it was the beginning of a new legal revolution. That was followed by the 19th Amendment, when the President, upholding his election pledge, curbed the powers of the executive and removed a part of the immunity of the President. Some were for total removal, but I said for the government to function, certain powers of immunity must lie with the President to make certain appointments, but others could come under challenge, and we moved for elections. Election itself was historic, that we formed a national government of the two main parties, some of the other parties. But we still remember that we political parties alone did not represent this revolution. It's the people outside who did that. So we still have to take into account the views of the people in how we go ahead and how we govern the country. I'm also, we have also appointed a committee to study the establishment of a financial city, a separate jurisdiction within Sri Lanka, within the land that is being, within the new landfill area, which should have a separate jurisdiction within the Supreme Court. How are we going to operate it? Because there is a demand for such a financial center between Singapore and Dubai. So we've asked one of the former attorneys general to head the committee, which will be drafting the proposals and discussing it with Honorable the Chief Justice and the Bar Association. These are part of the experiment. There are much more that we have to do. Gender representation. We just passed a law requiring 25% representation in local authorities should be reserved minimum for women. we have a bad record on that. Though we have had the first women parliamentarian was elected in 1931. We have to catch up on it. More than that, the question of legal aid, all this is good on paper. How to ensure that an ordinary person has access to justice? So what is the legal aid system we can have? And more important, how are you going to pay for it? Where do you find the revenue? So these are some of the issues that we are tackling in our quest to ensure that the rule of law is established in Sri Lanka. Of course, we run on 3 principles. One is that the sovereignty of the people in the executive, judicial, and the legislative fields are determined by Parliament. Secondly, that the rule of law must be supreme and administered by the Supreme Court. And thirdly, that power corrupts and absolute power corrupts absolutely. Thank you.